This is Democracy Watch. Mark, we have major news at the U.S. Supreme Court. We've watched as Donald Trump has taken these troop deployment cases to different jurisdictions across the country, L.A., Portland, Chicago. The Chicago case was appealed up to the Seventh Circuit Court of Appeals, which agreed with the lower court against Trump's troop deployment. Now the Trump administration has looked to the U.S. Supreme Court. So can you give a lay of the land of where we're at right now as far as the Supreme Court's concerned?
Yeah, so they have taken an emergency appeal or sought an emergency stay in the U.S. Supreme Court. The way this goes down is they will file that and it goes to a single justice, in this case, Justice Comey Barrett, and she refers it to the court. So she essentially operates as traffic cop, setting deadlines for when responses are due. But ultimately, the full court will decide one of a few things. Number one, do they want to issue a stay in the meantime? We've seen that. Do they just decide, you know what, we're not interested in this case at all? Or do they somehow reach the merits or expedite a reaching of the merits? What we know so far is that there has been no administrative stay so far. So far, the Seventh Circuit's opinion remains in force. Nothing there has changed. Responses are due to the Supreme Court on Monday, and then we will probably learn shortly thereafter, what the court expects that it is going to do here.
To what extent does the fact that the Trump administration lost at the trial court with Judge Perry and then lost at the Seventh Circuit Court of Appeals, to what extent does that have an impact on how the Supreme Court may rule?
Well, so it should have a big impact, right? I mean, if you read the Seventh Circuit's decision, what they basically said is that the trial court's decision was not, quote, clearly erroneous. Now, those are important words because clearly erroneous is the standard for findings of fact, right? So when reviewing courts look at things, they have to make sort of two sets of judgments. One is, did they get the law right? The second is, what were the facts? And trial courts are given very, very broad deference, to be the determiner of fact. On the other hand, the courts of appeals and the Supreme Court will review the legal judgments sort of with a fresh set of eyes. But what we have seen in recent months since Donald Trump took office that has really been disappointing in a lot of cases is that the trial courts find a certain set of facts. And I'll use LA as an example. The trial court, found a series of facts that basically said, there was no rebellion or insurrection or riot or, whatever the operative term was. And that should have been sort of the end of the story because An element of the legal justification is a finding of fact. But the Ninth Circuit basically said it's going to give, notwithstanding those findings of fact, it's going to give the benefit of the doubt to the administration. The Seventh Circuit here, I think, applied the right standard. And therefore, when this goes to the Supreme Court, this should be relatively easy because the Supreme Court is even further away from the underlying findings of fact. So that's one reason why that should matter. The second is just a very sort of practical reason, which is that at this point, you have had a trial judge, as you point out, make a decision, a unanimous Court of Appeals, which includes judges appointed by various presidents of both parties. And so presumably the Supreme Court is looking at that and saying, look, there really has not been any dissent at all across a wide spectrum of judges. And so let's not jump into this one. Of course, those are famous last words with this.
Right. Well, that's kind of what I want to dig into here, because I guess my question, for lack of putting this a different way, is how could it be that the Supreme Court even has any grounds whatsoever, or might have any grounds whatsoever, to claim that Trump has any justification to do this? The three conditions that need to be met, any one of the three conditions have to be that there's a foreign invasion, a rebellion, or a failure of the local government to be able to effectuate federal law. None of those things are happening. There is no insurrection happening. I mean, the most mayhem that we've seen out of places like Portland or Chicago are a few people in inflatable suits dancing outside of an ICE facility, and certainly no failure of the local government to be able to effectuate its laws. I mean, this is not something that the LAPD LAPD or the Chicago Police Department or the Portland Police Department can't handle. And I mean, by his, and judging against history standards, this doesn't even rank in the top 100 instances of any public disturbance. So if the Supreme Court does do what I think a lot of us fear they might do, which is lend legitimacy or defer to the Trump administration, how could they do that if it's so clearly if it's so clearly baseless?
Right. So let's lay out the three positions here. All right. So on the one hand, you have the position of California, Oregon, Illinois, Chicago, right? All the states, which basically say, look, these are the facts on the ground, just as you said, and judges determine that these are the facts, and this is the legal standard, and therefore facts don't meet legal standard. End of case, right? That's pretty easy to understand and makes a lot of sense to me and makes a lot of sense to you. At the other extreme, what the Trump administration is saying is that actually the president has sole discretion to make these findings, and they're unreviewable. That essentially judges can't even second guess them. There's no facts to find. That if a president declares that there is an insurrection or there is a rebellion or any of those other things, that's just the end of the story. That it's an unreviewable fact. And then someplace in between, and I don't think the in between is right, by the way, but somewhere in between is where at least some of the judges on the Ninth Circuit seem to be, which is, okay, we're not going to say it's unreviewable, but we're going to give this very, very, not just thumb on the scale, not even palm on the scale, but sort of like both elbows on the scale approach that says essentially like we can review it, but we're really going to credit extraordinarily strongly what the president says. And I just think that that's both historic. In other words, it doesn't square with the history of the law. It is contra originalist for the Constitution. It is not at all what the founders of the Constitution had in mind. It is anti-textualist, right? It's like there's nothing in the law or the Constitution that says that's like a made up standard that they have. But most importantly, it's also from a practical standpoint, it is a path to authoritarianism. I mean, you and I have talked in much lower stakes cases about the need for courts to abandon the presumption of regularity.
Right.
What the Trump administration says is not even a presumption; it's a conclusion of regularity. What I'm afraid the courts are trying to split the difference, say it's not a presumption of regularity; it is essentially an overwhelming assumption of regularity. It is really hard to overcome, and I just don't think that that's right. But that's what we're all going to be watching for to see what the Supreme Court says.
A quick aside for everybody who's watching right now. Everything that I'm learning as I continue to follow along with this case, whether it's in Chicago, Portland, Los Angeles, or any other city that Trump tries to deploy his troops into, I'm learning from Democracy Docket. So if you're not yet signed up for Democracy Docket, which is the news outlet Mark founded to focus on everything voting and elections, please do yourself a favor, support the work that Mark is doing, both on the journalistic front, but also to defend democracy where it matters most in the courts. Sign up for Democracy Docket. I'm going to put that link right here on the screen and also in the post description of this video. Mark, on this idea that Trump is the sole arbiter of who can determine whether or not any of those conditions are met, and it's completely unreviewable, if the whole point of Posse Comitatus is that you can't deploy the U.S. military against its own citizens, and that Trump, as the commander-in-chief, would be prevented from doing that, if he is the sole person who can review that power, then why have it at all if he, as the commander-in-chief, would be able to basically undermine it if and when he wants to?
Yeah, it's a really great question. I think to understand the extremism of the Trump position on not just this issue, but frankly, a whole range of issues that involve executive power, you have to understand that they take two maximalist positions. The first is that, sure, the statute says that, but it doesn't say who gets to make the determination. And yes, in normal circumstances, they would say courts get to make determinations, but not when it comes to the military. When it comes to the military, the statute is the law, but it is the president who determines, not the courts who determine how to follow that law. Now, again, that is unbelievably problematic and is, like I said, a road towards authoritarianism. But it's actually not even the worst legal theory they advance. The real underpinning of what the entire Trump administration's theory of executive power is goes like this. Article 2 gives the president certain powers, including the commander-in-chief power and the power to take care of the laws that are faithfully executed. And that power is unrestrainable. It is unlimited by a statute. In other words, a statute cannot restrict that power. And therefore, it doesn't matter what the laws say, because Article 2 trumps the laws, right? The Constitution trumps the statute. So they have a view of Article 2 that just basically says the president is the executive branch and he is a constitutional officer. And he is simply, when he asserts he is operating to either take care of the laws that are faithfully executed or as the commander-in-chief, that's the end of the inquiry. There can be no laws. There can be no restrictions on him. And that is not just a road to authoritarianism. That is authoritarianism. Right. That is what a king would have the power to do. And so it's important that we all support the movement against kings in this country.
I was going to ask if there's any precedent that the courts could rely on when determining the answer to this question of whether the president's power is unreviewable, but I presume that you're going to say that this whole thing is unprecedented because we've never had a president who tried to assert this authority. But correct me if I'm wrong. Has there ever been a situation, or is this completely unprecedented?
I mean, there have been situations for sure where presidents have exceeded their statutory authority or their constitutional authority, and courts have told them no. But it is unprecedented in the sense that there has never been a president or an administration that doesn't even try to operate within the lines. That is just, full-throatedly in favor of unlimited executive power. And that is why this is such a dangerous moment in history. It is the reason why, when I say that the position that they're urging is not just not consistent with the law, it's not consistent with the founders' intent when the country was started, and it doesn't have any textual support. I mean, the one thing that the founders were worried about more than anything else was an overpowered executive. Right? They restrained the power of the presidency through a whole bunch of mechanisms because that was the experience they were coming from. Right. So what has made this so aggravating, what angers me, what at times I just find frustrating beyond belief is that having been lectured for almost my entire legal career by conservative lawyers who tell me that what they believe in is originalism, is strict construction of the Constitution, is a government of limited powers, right? All of those things that we all always heard. Where are they now?
Yeah.
Right? Where are they now? They're lined up defending this guy when they have been lecturing Democrats saying, how dare Barack Obama think he can provide health care to Americans? Right? I mean, like think about the fights that we have had to get here. Right, the places where they have said that President Obama, President Biden, President Clinton had exceeded presidential authorities, and because they were the party of limited government and small government, and now they are defending the most expansive, most authoritarian view that one could imagine about executive power.
When thinking about this case, you and I have spoken about the case in Los Angeles, about the case in Portland, about the case in Chicago. I'm sure that we were prepared to speak about the cases that were probably going to butt up in New Orleans or New York or wherever Trump decided to deploy the troops next. But is the fact that we now have a case that's been appealed up to the U.S. Supreme Court, this is the one out of Chicago, is that once the Supreme Court rules here, will there even be need for any other cases in any other cities, or is this going to be the standard that the rest of the country looks at when determining whether or not Trump's troop deployments are legal? Like, have we reached the peak now of this whole question?
Right. So the first thing I want to say is that the question Brian's asking is the question of the future of democracy. And the best way for you to stay informed as these developments take place, and as, by the way, Donald Trump rolls out the military into other cities like San Francisco and New York and Oakland, all cities he's talked about, Memphis, right? The best way to stay informed is to hit the subscribe button to make sure you are subscribed to this channel, and then to hit the bell to make sure you are alerted when there are new videos posted, because that is the way Brian and I can keep you informed as all of these things move through the court. Now, to answer your question directly, it depends on whether the Supreme Court here just decides to do the minimum necessary or whether it decides to, as you say, kind of resolve the issue, right? In a world of judicial restraint, in a world in which the Supreme Court was, not putting itself into the middle of a political thicket unnecessarily, it would simply deny the stay, period. Right? It wouldn't have to rule on the ultimate merits. It could let this case percolate up through trial in the trial court, go up to the Court of Appeals, and it could do that, and it could just stay out. And then honestly, you wouldn't know what the Supreme Court thought. Right. People might speculate, but you wouldn't know because all they'd be saying is procedurally let this case proceed. At the other end of the spectrum, they can block it and say the reason we're blocking it is X, Y, and Z. And, we're going to essentially, through the shadow docket, without full argument, without all of the briefing, we're going to essentially resolve this issue. And look, I think that would be really dangerous for democracy. It is not what the emergency docket is there to do. I mean, the emergency docket is there to handle true emergencies like people on death row who, don't have the time to go through the normal process, right? But there is not a reason in a case like this why the Supreme Court needs to put itself in the middle on an expedited basis of what I think is a relatively simple issue, but if they are going the other way, is a very, very complicated question of what powers do governors have over their own state borders? What does it even mean to have a 10th Amendment or federalism if Donald Trump can take, a pretext and federalize the National Guard in one state and move them to another state? I mean, this is a thicket that the Supreme Court should stay out of, but we will only find out once they rule whether we know what they are thinking or whether this is just going to carry on for another day.
And finally, last question here. When can we expect some type of decision here?
So look, it's the Supreme Court. They can move on whatever timetable they want. I think that, in terms of the deadlines that Justice Barrett put in place, those are fast, but they're not crazy fast. Like, they are appropriately fast. So, I would expect that by the middle of next week, all the briefing will be in on all sides. And then it will be ready for a decision. So we could have something as early as the end of next week, or it could bleed into the following week. I don't think it'll go much past that. But again, one of the questions to be looking at is after we get to the briefing, on Monday, Tuesday-ish when it's completed, does the Supreme Court put a stay in place while it is deciding the case, a so-called administrative stay or not? And that will at least be the first clue of perhaps where they're going.
Well, look, again, a reminder for everybody watching, the best reporting happening right now on this issue is on Democracy Docket. So if you're not yet signed up, I'm going to put that link right here on the screen and also in the post description of this video. If you're not yet signed up, please go ahead and sign up. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.